Elrigu Namaskara. A very good evening to all the ladies and gentlemen. Welcome you all for the post-budget analysis of the indirect taxes. I am Rupa, Secretary at BCIC. The Chamber acknowledges the immense support of today's esteemed speakers for having accepted our invitation to interact with our members. Mr. P.V. Srinivasan, Mentor PVS Advisors. Thank you very much, sir. Mr. Shivadass, Senior Advocate, Shivadass and Shivadass. Thank you very much, sir. And we also will be having Mr. Balasubramaniam, Joint Secretary, Revenue Department, Ministry of Finance, joining virtually. And today's session is organized under the aegis of indirect taxes, led by Mr. Badrinath, partner of Singhvi and Unni, LLP. Thank you, sir. And co-chaired by Mamatha Anand, partner Deloitte, and Arun Ramachandran, who is the head finance at Tata Consumer Products. The Chamber acknowledges the immense support of today's event sponsor, Singhvi and Unni LLP, Sansera, West Coast Paper Mills, and Shivadass for their contribution. The Chamber also acknowledges the support of our annual members, the annual sponsorship from our member organizations in all the activities of the Chamber during the year. Before I hand over the stage to Mr. Badrinath, I would like to briefly introduce him. Mr. Badrinath has over 25 years of experience, specialized in central excise, customs, service tax, foreign trade, and GST. He has played a pivotal role in conceptualizing, designing, and implementing tax-efficient business models across various industries. He is also a member of GST Grievance Redressal Committee, jointly set up by the central and state government. He is recognized for his representation skills before indirect tax appellate authorities and his advocacy efforts with both state and central governments on tax-related matters. I now invite Mr. Badrinath to take it over from here. Over to you, sir. Thank you.
Thank you. Thank you, ma'am. A very good evening to all of you. So, as all of us know, we are going to be talking about the 53rd Council, the recommendations that came through that, and the consequent circulars and the notifications, including what happened 2 days back, which is the budget. So, in summary, if I may say so, a lot has happened from an indirect tax point of view in the last 1 month. So, we are going to try and look at how it impacts our businesses, what are the matters that we should keep in mind in our decision-making process. So the format for today is going to be as follows. First, we'll have an hour, slightly more than that, a presentation from Mr. Shivadass, who's going to walk us through in terms of these amendments, which I believe are very important for all of us. Second, we'll have Mr. Balasubramaniam. He's the Joint Secretary, Tax Policy Research, who's going to be joining us virtually. He's going to share his thoughts in terms of what has the experience been and some key changes, the thinking of the government behind those key changes for 30 to 40 minutes. And then we'll have a panel discussion where we'll have Mr. PVS and Mr. Shivadass on the panel, open to all the questions. So before we request Mr. Shivadass, yes, so I've been given a sheet of paper to introduce Mr. Shivadass. I don't think I need that. And anyway, let me put it this way, very casually if I have to say, sir, I don't think anybody sitting here needs an introduction of Mr. Shivadass, right? He's one person, whenever I go to the tribunal, I always look forward to, if he's there, it will be good to hear him, right? So it is like that. I actually keep bothering him a lot of times. He's been the mentor for the Indirect Taxes Committee at the BCIC. So a lot of times I misuse his name also internally. Thank you, sir, for that. So he's a senior advocate, as all of us know, since 2018, designated by the Karnataka High Court. Of course, goes without saying, he appears before the High Court and before the Supreme Court and various other High Courts. He was previously with LKS. Now he's the principal leading Shivadass and Shivadass, the legal firm. With that, let me take a minute before we kind of go there. There are quite a few changes which have happened. Whether we talk about stock options or when we talk about corporate guarantee, we talk about an amnesty scheme. we talk about the recognition which the government wants to give for an industry practice. There is a new section which has been inserted, which kind of goes beyond the law to recognize what an industry practice is and keep it out of the tax net or accept the tax that is being paid or not paid the way it is. So we'll understand this and possibly more. In summary, there have been about 16 circulars which came the next day after the council meeting, a long list of amendments to the CGST rules, and the corresponding, the other changes which required an amendment in law have been covered yesterday. So we are going to hear this in summary from Mr. Shivadass. Sir, please. May I request him to come on, please.
A very good evening to all of you. It has been at least about 3-4 years since we have really had a budget session in a physical manner, and after the introduction of GST. We have lost that charm for that budget. Earlier it used to be after the budget is released, the next 2 days we used to have the physical conference, and then it used to be an event we used to look forward quite eagerly. But after GST came, the significance of the budget for the indirect tax has been significantly reduced, which also is right, because the whole method of implementation of GST is in a slightly different method, by which the GST Council discusses, comes out with recommendations, and thereafter the sections are framed and then the rules are framed. So it's more a collaborative effort as far as GST is concerned, not unilateral as it used to happen earlier. So to that extent, the existence, or rather I would say the use of the budget for understanding GST has been reduced. But surprisingly, this year, maybe it's because the 53rd the GST Council meeting happened, and thereafter the circulars got issued, and immediately thereafter the budget also was announced, and then the amendments that were suggested in the GST Council meeting also came to be implemented through the passing of the sections and the rules. So therefore, this is one session where we can discuss in some detail both the amendments to the CGST Act and the rules. And we also thought that we should have a discussion on the series of circulars that have been issued by the government from the last 1 or 2 months. The one thing which I always keep seeing and thinking, and I always used to talk to PVS sir also, the proactiveness of the government in trying to solve disputes that are raised to them by the industry, articulated to them by the states, is evident from a series of circulars that get issued from time to time. And most of the circulars are quite neatly drafted, examines issue in quite detail, and tries to give a solution which is in line with what the Act also contemplates. There are some circulars, some issues where the views taken are slightly in aberration, but otherwise generally, if you can see, the circulars are quite favorable to the thinking of the trade. And I think a lot of credit should go to the government for that. And maybe Bala, who will come on the line after some time, would be playing a great role in having these circulars issued. Because from whatever I hear from people who come to meet all of us, they always keep saying that yes, we have gone to the North Block, we have met everybody, they are quite open to discussing the issues which we have raised, and they said yes, they will be coming out with circulars, and the circulars do get issued. Now, it's a different thing that there is a disconnect between the manner in which the circulars are issued and the way it is interpreted at the ground level. That there is a huge disconnect. So, the effect of the circular or the intended benefit from the circular doesn't go to the assessees in the manner in which it is intended. Now, that's a problem at the ground level. Now, that's where we are trying to impress upon the courts to somewhere tell the department that they should start respecting the circulars when they are issued. There is no point in trying to say that we distinguish the circular on this point and still continue to hammer the issue on the same point which the circular tries to address. So that problem has to be solved. Hopefully at some point of time, some courts will come down on that and say that start respecting the circulars. So we thought we will do that combination of looking at the amendments and then the circulars so that we can have a fruitful discussion thereafter. Because I have the benefit of having PVS here with me. So contrary to what he thinks, if I go wrong, he is always there to tell that I am right, even if I am wrong. So that's the biggest benefit I have if PVS is there with me, right? So let's quickly have a look at this will be the agenda. We'll have a look at the customs, GST, and then the recent circulars. Customs, quickly run through the amendments. Can you put off the light so that people are able to see? Some of the lights you can put off? No, just see. Otherwise it will be too much of... So, small amendment they have made to this section 28DA, where if you have to get the preferential rate of tax, then you have to produce proof regarding the certificate of origin. And there are few mandatory issues, mandatory claims which will be examined by the authorities based on the certificate of origin, that they have slightly modified the certificate to say proof, and whatever contemporaneous documents you have to demonstrate that you have purchased from a particular country and there the value addition has been made, all that I think will go with the certificate, that the proof that has been done. Of course, it's always open to them to examine the correctness of this proof which you have produced and reject the proof if they are not satisfied. That right is always reserved by them. But otherwise, wherever the expression certificate is there, that has been replaced by proof, so that any other contemporaneous document also can be used in this. There was a section 65 which was earlier applicable to all the EOUs and EHTPs, the earlier regime of bonded warehouses, and that bonded warehouses came to be replaced somewhere in 2016 or something, to say that now no more EOUs will not be considered as a bonded warehouse. And simultaneously they also brought in this manufacture and other operations relation to goods in a warehouse rules, MOOG rules as they call it, where you can undertake operations which normally you will do in a bonded warehouse, but outside the bonded warehouse in any other normal warehouse operations. So this was introduced, and this was essentially enabled to have other players other than EOUs also to undertake activities within the warehouse and for the purpose of export. Now there were quite some ambiguity in the manner in which manufacturing process was defined for the purpose of these rules. Now that evidently they found that there are some difficulties in the interpretation of the expression manufacturing process. So now they have said that the government will have the power to notify the manufacturing process which will not be permitted in a warehouse. So they may come out with some sort of a negative list of operations which will not be permitted in a warehouse which are operating under these rules. The impact of it we will come to know once the rules are framed under this. Now, there was some issue regarding the compensation cess being levied on imports made either by the SEZ units or developers, because whether the compensation cess is also exempted in case otherwise the customs duties, because essentially an SEZ unit will have no taxes being levied on it, either on its import or on its domestic activities. Therefore, whether a compensation cess also getting exempted was an issue. Evidently, it was raised to the government, and then they have exempted this with effect from 1/7/2017 to be in line with what the SEZ Act also envisages. There are few changes that have come about in this customs tariff. I'll quickly run through it, where they have raised the rates of taxes on some of the items. For some of the items and all, the rates are increased very exponentially. Similarly, there are modifications to some of the existing customs notification 50 of 2017. They have identified few sectors like an agricultural sector or a pharmaceutical sector or a manufacturing sector. All of this they have identified to say that we want to give certain specific exemptions or reduction in the rates of tax. This is more with reference to what has been represented to them, either because there is no local manufacture of it, or the local manufacturer is not supportive enough, and therefore they have to encourage import of raw materials but at a lesser tax, so that easier for us to encourage more of indigenous operations. These are some of the items. Dore bar, all the gold, etc., they have reduced the rates of tax. All individual items which are meant for a particular sectors, PCBs, then parts of cellular mobiles, phones, to encourage more the indigenous production of these items. Then something to do with metals. Because there is a continuous review of these customs notifications from time to time. In fact, if you remember last, I think couple of budgets before, the government had promised that we will review all the customs notifications exemptions, so that at some point of time either these exemptions are phased out, or based upon the utility of these exemptions will be removed. So that's a promise I think 2-3 years before the government had made, and that continuously that exercise is being done. Similarly, some of the countervailing duty notifications are, the procedures have been modified. So periodical reviews needs to be done, how individual subsidy margins have to be examined. So this entire process is essentially to ensure that this process goes through seamlessly. Otherwise, we had handicaps in the subsidy rules or in the anti-dumping rules, where there is a yearly review, quarterly review, how to do it, etc. They seem to have streamlined these procedures. This is again clean environment cess levied and collected as duties of excise is being exempted on excisable goods lying in stock as on 30th June 2017, subject to payment of appropriate GST compensation cess on supply of such goods on or after 1st July 2017. So these are all things that have been examined based on the representations given to them wherever these issues were raised, and these exemptions notifications have been issued with retrospective effect. Now we will look at the amendments in GST law. Now one is section 16, where the one good amendment that has been made is, as you are all aware, there is a time limit for taking input tax credit under the GST law. So it will be up to the September of the next financial year. So April to March of one financial year, you can take credit up to the September, or they extend it up to November up to a particular time, essentially up to September of next financial year. So for 17-18, you can take up to September 18. That was the time limit that was prescribed. Now there were any number of reasons where companies were not able to take the input tax credit, either because they were not able to adjust to the new rules, or they were not able to get into the procedure of getting their invoices uploaded, suppliers getting their invoices uploaded. Any number of situations were there. Now, there were continuous representations to the government saying that yes, you need to have a relook at the time limit, at least for the first 2 or 3 years. Then there were problems that came about because of the wrong mentioning of the GSTN numbers of the purchasers, group companies, different GSTN numbers being mentioned. All that was coming about. The government did issue circulars from time to time saying that yes, look at these, the contents of it. Have they really complied with the law in substantial manner? Are there only mistakes being committed in terms of the documents? Therefore, don't disallow credit because of these reasons. Circulars got issued. The government, at the field level, there was a repeated attempt to deny the credit. So we had to go to the courts. The courts had to interfere. The courts also looked at the genuineness of the claims made. There were quite a number of decisions that said don't stick to the time limit in the initial years when everybody is in a state of flux. So looking into all that, the government seems to have discussed this quite in detail in the last couple of GST council meetings. And then I think for 3 years, 17-18, 18-19 and 19-20, they have introduced a provision by which the time limit to take input tax credit of whatever taxes is being paid during these 3 years, the original time limit of taking credit up to the September of next year will not apply. In other words, you are now entitled to take credit of the tax paid during these years, even up to September, up to November 21. This is a big relief that has come to the industry to say that yes, we are enabled to take input tax credit, because input tax credit is as good as a check payment by a company. So therefore, they should be allowed to take it. This is a welcome move by the company, and this is how it has been done. In respect of any debit note of supply of goods or services pertaining to the financial years 17-18, 18-19 and 19-20 and 20-21, the registered person shall be entitled to take input tax credit in any return under section 39, which is filed up to the 30th day of November 2021. Now, they also indicated that where there has been a cancellation of the registration, because the system was designed in such a manner that if you don't file your returns for a period of 6 months consecutively, and if you don't file your return, you can't pay the tax. It's very intricately connected, that you have to, whether you pay the tax and then you file your return, or only when the return is filed, the payment of tax is recognized. And we as lawyers, the courts, all of us contribute to the confusion. We keep arguing that what is a return? Is it a return under 39? Is a 39 a return? What is a format? All those confusions did come up. Courts also contributed to it. There are some decisions that said that whatever you file originally under 39 is not a return. Therefore, the provisions of time limit will not apply. Now, all that seems to have been fairly settled. Therefore, they have said that for these years 17, 18, 18, 19, 19, 20 and 2021, the input tax credit can be taken up to the 30th day of November 2021. So now they have given this relief up to 2021. After this, essentially from 21-22 onwards, mostly things have got streamlined to a larger extent. There could be issues even after that for specific instances, but otherwise generally companies also have got used to the way they will file the returns, conduct their affairs, etc. So that problem would have been solved. Now whether this will continue post 2020-21, say 21-22, 22-23, we don't know. But for the present, they have given relief up to the period 2021. Now, similarly, where registration is cancelled and subsequently the cancellation of the registration is revoked, because if you don't file your return in 6 months, then there is an automatic cancellation of the registration. Then we rush to the court. The court will, invariably the courts have said, who suffers because of the cancellation of the registration. It's not only the assessee, the revenue also equally suffers, because there is somebody who wants to do business, somebody who wants to pay the tax. Now if you cancel his registration, how will he do business, how will he pay the tax? Therefore, restore his registration, allow him to file the returns even if it is to be done manually, allow him to pay the tax and allow him to do his business. Now, once you allow that, there is a corresponding input tax credit also that he would be entitled to. But if you apply the provisions originally as it stands, he can't take the input tax credit. So, this is one other move where they have indicated that even if it is cancelled and thereafter that registration is revoked, then he will be entitled to take input tax credit in respect of such invoice or debit note up to this particular period. So, this amendment, according to me, is a good move by the government to provide relief at least for the first 4 years. And providing this relief for a period of 4 years is, according to me, is extremely good on the part of the government, because very rarely they have done it even in the past. If the rules are there, rules are there. How the courts interpret it, we will leave it to the courts to decide. But for the government to proactively come out and amend the law and then to say that yes, we will allow you to take credit, I think is creditable to the government. So this is what happens. In brief, 16.4 time limit has been extended up to 30/11/2021, and ITC will be available for assessees whose registration has been cancelled. This again is one other amendment they have made, where they have removed ENA, or the undenatured extra neutral alcohol or rectified spirit, which is used to manufacture alcoholic liquor for human consumption outside GST, because it did not make any sense if the ultimate final product, namely the alcoholic liquor, is not covered by GST. The raw material which is used to make this alcoholic liquor is sought to be taxed under GST. There were instances where some of the state governments did raise demands on GST on this ENA, on the ground that what is specifically covered under GST, outside the GST is only the alcoholic liquor. This is not alcoholic liquor for human consumption in the manner in which it is coming out or is being used, and therefore we would like to tax it. Again, litigations were there, representations were made, and subsequently they have come out to say that if we are taking out alcoholic liquor, we will also take out ENA that is used for alcoholic liquor. Makes a lot of commercial sense. Now, this is something which, as Badri was pointing out, a new provision of section 11A that has been introduced. Now, for all of us who have been practicing excise or customs for so many years, this provision, according to me, should have been there in the GST law as it had come. We had a section like this in Excise Act called 11AC, section 11AC. Now, the law provided that if in an industrial practice, you find that certain group of industries or section of industries were having a bona fide belief that we are not liable to pay the tax, and therefore they did not pay, but few others paid, then do you raise a demand in respect of those groups of companies who have not paid the tax, or do you recognize it as an existing practice being done by a number of companies, recognize it and say that you have not paid, fine, we will not raise any demand on you till this date, but from this date onwards we will ask you to pay the tax. So prospectively it becomes applicable on a particular sector. Everybody comes into play, all of them start paying the tax. As far as the past is concerned, if you have not paid the tax, so be it, we will not ask you to pay. If you have already paid the tax, you cannot ask for a refund. That used to be the position always. And this they have now brought in under the section 11A. How this will span out in the ground, I am not too sure, because this can have, because the timing in which this section has come out is slightly intriguing, and I'll tell you why. See what this section says: notwithstanding anything contained in this list, if the government is satisfied that a practice was or is generally prevalent regarding levy of central tax, including non-levy thereof, on any supply of goods or services, or both, and such supplies were or liable to central tax in cases where according to the said practice central tax was not or is not being levied, or a higher amount of central tax than what was or is being levied in accordance with the said practice, the government may, on the recommendation of the council by a notification in the official gazette, direct that the whole of the central tax payable on such supplies, or as the case may be, the central tax in excess of that payable on such supplies, but for the said practice, shall not be required to be paid in respect of the supplies on which the central tax was not or is not being levied, or was or is being short levied in accordance with the said practice. Essentially regularizes the non-payment of tax. A classic example, when this section came, everybody thought that this section is enacted to help a certain set of players who were having a huge problem on the payment of tax, namely the gaming industry, the online gaming industry. Now, whether you should pay on the platform fee, or you should pay on the deposits also that are collected from players who want to play in the play the game. So should you ask them to pay tax on the entire amount? Because essentially most of the companies were paying on the platform fee, but they were not paying on the deposits or on the winnings. What happens? Now in 23, they brought in a specific, after all of you know, the decision of the Karnataka High Court in online gaming, a number of high courts following it, all of them are now bunched and being heard by the Supreme Court. Now, is it a game of skill, game of chance? Is it the same as gambling? Is it the same as betting? Where do you draw the line between game of skill and game of chance? Huge number of problems are there in all that. So most of them were playing on the platform fee, but not on the deposits. So if you look at the law, in 23 they amended the law. They brought in a definition of online gaming. They brought in a rule that said that for online gaming you will pay tax on the entire amount, including the deposits. Now what happens to the past? Huge demands. I mean, I am told about 1 lakh crore and odd has been the demands raised, and about about 13,000 crores also has been, either 13,000 or 10,000 crores has been realized by the government so far. But for this, therefore, there is a practice there, people were not paying on the deposit amount. So how do you regularize it? Are you asking them to pay on the entire amount, or do you regularize, accept it? Because essentially, once you bring in a provision subsequently, it can't be applied for the past. Taxing provisions can never apply for the past. Therefore, how do you regularize it? This is one classic enabling provision by which it can be regularized. Now, whether it will happen, we don't know. Now, like this, there are any number of instances. Now, therefore, this section essentially enables them to also come in play wherever they need to help people. For example, health sector is one where there are instances where tax has been paid in respect of certain activities, not paid in respect of certain activities. They are asking for the past. Any number of sectors are like this. Therefore, this will enable them to identify those areas where there is a non-payment for the past, but there is a practice, and therefore we will recognize the practice and allow you not to pay. We will not raise retrospective demands on that for the past. Future going forward, pay the tax so that it becomes easier also for the industry. That's the whole purpose of this section. Yes. Now, these are amendments that have been made where there will be a background to this. We will come back to the slide after some time, because you look at this slide now, you will not have much of a. Now, this is one. Section 13(3) has been amended, in terms of which the phrase by the supplier has been substituted by the supplier in cases where invoice is required to be issued by the supplier or a new clause has been issued, the date of issue of the invoice by the recipient in cases where invoice is to be issued by the recipient itself. This essentially applies in the case of reverse charge mechanism. So, in a reverse charge, either the supplier has to raise an invoice and then payment of tax takes place on a reverse charge basis, where it happens both the suppliers and the recipients happens to be in India, or where the supplier is outside, the recipient is in India, the supplier is not registered in India, he is outside India, therefore he is not registered in India. So, the recipient will be liable to pay the tax. So, he will raise an invoice, and he will raise an invoice, pay tax, and based on that invoice he will take the credit. So, that is how the entire reverse charge mechanism operates. Now, we had an issue, what will be the time of supply in respect of these cases where RCM payment is there? Will you go by the supplier's invoice, or will you go by the invoice that is raised by the recipient in India who raises it as a self-supply invoice? So, will you go by that? Now, they have said yes, we will go by the time, the date on which that is the recipient raises an invoice for his reverse charge mechanism, and they also said when you account for it in your books of accounts, the recipient accounts for it in the books of accounts, that will be considered to be the time of supply. This will help a lot of companies where reverse charge mechanism happens as a result of import of services from countries abroad. Right? This will help in all those situations. Local reverse charge mechanisms, this may not really be so much relevant. Outside the country, where for example they keep raising these issues on import of software, or the license is being imported, then software services are being provided. These are all cases where these provisions can come into play. Yes. See, this one, we will have a slight background to this. I mean, all of you are aware, the demand provisions under the GST law is section 73 and section 74. 73 is where there is no suppression, misdeclaration, etc. 74 is where there is a misdeclaration, suppression. Similar to our old 11A or the 11A proviso under the Excise Act, or 28 or 28 proviso under the Customs Act, or the 73 proviso under the Service Tax Act. But in GST law, they had very nicely delineated both the situations under 73 and 74. For some reasons in this budget, they have made both into one. Now, when it is a 73 proceedings, where there is no misdeclaration, etc., if the supplier who is liable to pay the tax does pay the tax on a subsequent date, the person receiving it can take credit. Invariably, if somebody can take credit, no supplier will hesitate to pay the tax. That's because why should I hold back payment when I can take, somebody can take the credit, then we will make the payment. But this credit availability was a problem if the proceedings were initiated under section 74, because the government thought if you have suppressed the information, etc., and then we are finding it out, we are asking you to pay the tax, you should not be allowed to get away by giving credit to the person who purchases from you. Therefore, they said that if it is a 74 proceedings, the person purchasing from you will not get the credit. That is why in GST, if you see, most of the notices are getting issued under section 74, which is wrong. Even in normal cases where there can be no suppression also, you should go under 73 and get credit, right? Now, that the person cannot get credit is because of a prohibition under section 17(5), where they say input tax credit shall not be available in respect of the following, namely, any tax paid and provisions of section 74, 129 and 130. Now, 129, 130 is your confiscation proceedings. 74 is where the proceedings are initiated alleging suppression. Therefore, 17(5) said you can't get the credit. Now, they have said restricted the 74 in respect of any period up to financial year 23-24, because 73 or 74 will be applicable only up to 23-24. After 24, the new provision of 74A will come into play. I will come to 74A in a minute, right. Therefore, the idea is that this prohibition of 74 being there as an impediment to get credit is because of 17(5), and for some reason, even after enactment of 74A, 17(5) doesn't make a reference to 74A. In other words, I am not too sure, is it conscious decision or is it by mistake, I am not sure, but if it is a conscious decision, that now that we have integrated 73 and 74 together, it is only one section 74A, we will now look into the availability of credit. We will allow you to have a full go at the credit. And this, according to me, also may be true, because when we look at some of the circulars that have been issued from time to time, the government is very clear. If somebody takes credit, we go by your value. If somebody takes credit, we go by your value. Whether that the person taking credit is your own related person, not your related person, whatever be it, we will go by your value, which according to me is a very sound principle in tax laws. At least 60% of the disputes would come down if that principle is adhered to at the field level. 60% of the disputes, because most of us would be aware, most of the cases the company is receiving will take the credit. Very few cases where the receiving companies are in a sector where there is no payment of tax, exempted sectors, health sectors, etc., that issue can be there. Otherwise, most of the cases companies receiving will take credit. If that is recognized in law by the administrators, most of the disputes will come down. Now, this again comes back to the issue of an invoice on a reverse charge basis. So, they have modified accordingly all other rules that are required to be done for the purpose of integrating that section 13(3). Now, as far as a TDS, a person deducting TDS is concerned, the old section indicated that they has to file a return, and within 10 days or a month after the deductions has been made. Now the issue was, suppose there is no deduction to be made in a particular month, should he file a return? Because there is nothing to be indicated in the return. So should he file a return? They have clarified it to say that whether you make deduction or not, you have to file a return. So compulsorily every month you will have to file a return. Slightly one more document to be done where the tedious deductions are being made. This again was something which I don't know whether any mischief was noticed, etc. or not. There were goods that were subjected to export duty. So export duty is where certain goods are identified, and in order to prevent goods being exported, export duty is being levied, right, so that to make it more available in the country. Export duty is a customs duty. So you pay customs duty, you export it. Now IGST also may be payable along with that. Now what used to happen, I don't know, that could be the possible situation. People will utilize the credit, then you will pay export duty in customs in cash, and then you will pay IGST utilizing the credit and get that credit back as a refund. So you monetize the existing credit that is available there. I am not too sure whether they found any misuse in that scheme. So therefore they have amended this to say that no refund of the unutilized input tax credit on account of zero rated supply of goods or of integrated taxpayer on account of zero rated supply of goods shall be allowed where such zero rated supply of goods is subjected to export duty. So if it is subjected to export duty, you cannot get a refund of the unutilized credit. In other words, you cannot utilize the credit and pay the duty, that refund they will not give you. You cannot get under 54 the unutilized input tax credit also. So whatever is there as an export duty, they ask you to export duty on payment of cash and stop with this, nothing beyond it. This they have said authorized representative also can attend the summons, and more important is they said the person so appearing shall state the truth during examination or make statements or produce such documents and such other things as may be required. So whoever attends apart from the company's representatives, whoever attends as an authorized representative, his statement also will have a greater evidentiary value as far as the facts of the company is concerned. Yes, this is what I was pointing out. 73 earlier was with reference to cases where no fraud, willful misstatement was there. 74 is where fraud, misstatement is there. Now this have been restricted up to the financial year 23-24. Right. Now of course this will also depend upon the day on which the annual return has been filed. So the 17-18 annual return gets filed, I think somewhere in Feb 20 or something, Jan or Feb 20. That is a date it was extended from time to time. I always keep saying, when people came to us at that point of time, should we ask for an extension of the time? I said you can ask for an extension, but you also have an inherent risk in it, because the section is worded as from the date of the annual return. The moment you ask for an extension of the time limit to issue a notice also gets extended, and that is how for 17-18 it is extended up to 2020, and 2020 the time limit is up to 2023, and now by virtue of those extension notifications it has got extended from 2023 even up to 24 March or something. So for a normal 17-18 situation, you have now a time limit to issue notice up to 2023, 6 years they get, right. So what they have done is, this will be restricted only to 23-24. The reason is they have introduced this 74A. 74A essentially combines both 73 and 74. So whether it is on account of suppression or no suppression, everything will be covered under this 74A. And more important is the time limit for all this for 74A is essentially, if you look at 74A2, the proper officer shall issue the notice under subsection 1 within 42 months from the due date for furnishing of annual return for the financial year to which the tax not paid or short paid or input tax credit wrongly availed or utilized relates to, or within 42 months from the date of the erroneous refund. So, it is from 36 months, 6 more months have been added, right. What was normally 36 months for the passing of an order under 73 has now become 42 months for the issue of a show cause notice, right. Now, when will the adjudication take place? Now, if you look at it, this says, this is all the other clauses. In terms of 74A5, the penalty in a case where a reason other than reason of fraud shall be equivalent to 10% of the tax. In all other cases, it will be equivalent to the tax. So, 73 proceedings 10%, 74 proceedings 100%, both made as part of one section 74A. So, now there is not much of a difference between situations where suppression is there or suppression is not there. It is only with reference to the penalties that these sections will provide a relief. Otherwise, as far as the tax is concerned, whether you are liable to pay, the limitation in terms of the present scheme would not be of any use post 74A, right. The 6 months, 5 years we used to enjoy in earlier 11A or 28 will not be available under GST. Now, once this is done, the officer gets a time limit of 12 months from the date of issuance of the notice. So, he gets 12 more months. So, 42 plus 12 months, which is 54. So, he can issue the order within 54 months from the date of your annual return. And they have also given 6 more months to the officer to extend it by another 6 months. So, 60 months is the time limit available to them in all cases. Whether suppression is there, suppression is not there, they will get a time limit of 60 months, right. So, what is today available within 3 years has effectively been extended by virtue of 74A. So, the relief you will get in terms of this section is only with reference to the penalty of 10% or 100%. Otherwise, you have to argue on the merits of the matter, whether you are entitled to the rate of tax which you have paid, which means we have to be more careful in deciding the rate of tax which we are liable to pay. And when we decide what rate of tax we have to pay, they are also clear. Please take into account the fact whether your purchaser can get credit or not. If he gets credit, we will not stop you from having any value, of course subject to the basics that at least the minimum cost etc. has to be covered. We will not get into all that, but the moment we get into the act and we establish that you have paid less amount of tax, then you will have no recourse other than to pay tax. You get a relief only in reference to the penalties. More responsibilities on all of us when to ensure that the rate of tax, the amount of tax is correctly paid. Now, this continues. These are penalties that they have indicated. How much, suppose you have to pay before service of notice, then it will be a certain amount of percentage. Then after the order, if you pay, what happens? So different situations we used to have. Before the show cause notice, if you pay, no penalties. After the notice, if you pay, about 10 or 15% penalty. After the order, if you pay, it will be about 25% of the duty as penalties. You don't pay all that, subsequently you will land up, then whatever consequences you get from the courts, you take it. Now, therefore, this continues. There seems to be an attempt to simplify the time limit by prescribing uniform time limit in all proceedings. In fact, this is the only line you would have heard the finance minister say. This is the only line you would have heard the finance minister say. In the GST law, we are streamlining the procedures to ensure that there is uniform time limit in all proceedings. This is what it is. But the devil lies in the fine print. However, an additional time limit has been provided for cases initiated for reasons other than fraud. So, 3 years is now made as 42 months plus 12 months. Right? In fact, I am not too sure whether they are putting it in line with even the Income Tax Act, where also it is coming into 5 years, 6 years, because this suppression, no suppression is a distinction which was maintained only in the central indirect tax acts, the excise, customs, service tax law. VAT law also, for all of you would know, does not recognize that concept of suppression, etc. It is only an assessment, reassessment, evidence coming into play, evidence not coming into play. Only these central taxes recognized that. That also I think they want to do away with and restricting those ingredients only insofar as penalties are concerned. Now, this once they have introduced 75(2)(a), where they say that in case the willful misstatement, etc., is not established, then penalties will be in terms of 74(a)(5). The 10% penalty will come into play because of that. Now, when I go through the further the amendments and then the circulars, I will also try to give my view of whatever you people have asked so far. So, that could be slightly different from whatever has been explained. This amendment is made reducing the amount of pre-deposit. Earlier it used to be that 30%, and now it has been reduced to a certain amount, and these are effective from 1/8/2024. The good news is that the GST-AT is expected to function by the end of this year. We hope that no further High Court stays the constitution of the GST-AT, constitution of the members and all that. Now, on this pre-deposit, one of the questions that was asked is, we are being asked to, one of the circulars that got issued saying that yes, you pay 20%, then you will get a stay of the remaining, etc. Is it not being unfair to the taxpayer, because the non-constitution of the tribunal is not their fault? It's a genuine grievance. The problem all of you should realize is that if an order is passed where the appeal lies to the GST-AT, we have two choices. One is to go by the circular and get a protection for the remaining 70%. In fact, that method that is prescribed in the circular is what is essentially approved by a number of high courts. There are a number of high courts that have taken that view. You deposit 20% because that is what the law requires you, and we will not, we will give a stay for the remaining. So, that is something which the High Court has, number of high courts have taken that view. Now, if you want a different approach, maybe you should approach the high courts in a particular matter and demonstrate to the High Court that maybe that view of the appellate authority is wrong because of any number of reasons, and get a stay from the High Court on the entire demand. That is an approach that should be available, that is available to the SSC. We will have to make use of it. Now, this is the constitution of the appellate tribunal, that they will be setting it up, and then the special bench will be in Delhi, the principal bench as they call it, and then the other benches. The principal bench essentially will be hearing matters relating to the place of supply, that will be heard by them, in addition to whatever the president assigns it to them. In all other cases, it will come to the respective the state benches or the regional benches. The time limit will start after they issue a notification for accepting your appeals. This is in respect of certain activities. They have amended section 122B, where electronic commerce operator doesn't comply with the law, then the penalty is being modified. This is what somebody was asking, 128A waiver of penalties. What will happen if for this period the amount is paid, and then will there be a waiver of interest and penalty? If there is a notice under 74, therefore, why that is not extended to 74? Their logic is right, because you can't normally, no amnesty scheme gets extended to any assessee who is accused of fraud, suppression, etc. No amnesty scheme gets extended. But the difficulty is, in most of the cases, fraud is invoked. See, if there are cases where genuinely fraud is not there and still fraud is invoked, you lose the benefit of this amnesty. Therefore, the approach would be, if you look at it, this is for the period 2017 to 2020, and they will indicate a date by which it has to be notified. According to me, I think in one of the circulars or something, they said if you pay up the amount by March 2025, then you get the benefit of the scheme. Now, how do you make use of this amnesty? Suppose you are issued with a show cause notice under 74 today, and the amnesty scheme is not applicable to somebody to whom a notice is issued under 74. Now, there is also a provision in GST law that says that if a notice is issued under 74 and the High Court or any court for that matter converts it into a notice under 73, that is, it holds that there is no suppression, etc., then all consequences relating to that proceedings under 73 would be available. So, what should be done ideally is, if you have a notice under 74 today and you have to avail the benefit of the scheme, and if you have to make a payment before 25, right, and according to what Bala said, it is not enough if you make a payment before 25, you also should not pursue any litigation further. You should not pursue any litigation further. So, in other words, you should conclude it as a proceedings under 73. How do you do it? Therefore, in appropriate cases where there is a notice under 74, and if you feel that that 74 invoking is wrong for whatever reasons, either because the notice is issued based on a clarification that is issued or based on any situation, my suggestion would be you should approach the High Court on a particular case, because whether 74 is to be invoked or 74 is not to be invoked, because whether suppression is there or not there also is a question of a jurisdiction before the High Court. So, you should approach the High Court, tell the High Court that in a particular case 74 will not come because of these reasons. It will only be a 73 proceedings. Get an order from the High Court that this proceedings under 74 is wrong. This can only be a proceeding under 73. use that High Court order to avail this amnesty scheme, and all this has to happen before March 2025. Now, you do not ask me whether it will happen before March 25, but I can only tell you you should ensure it happens, and I do not know how you can ensure it happens, but that is what that's an option that is available to you.
Small improvement, I would say.
Yes, sir.
Make the deposit also and state in the request and say that we have made the deposit and we want to qualify.
Therefore, please decide the matter before 25. Correct.
Also say if this restriction of the law can be overcome through a court saying that I am pursuing this litigation to classify whether I am 73 or 74.
Only.
Therefore, I paid.
Absolutely. Yes. That's one way. As always, PVS adds that glaze to it. So, pay the tax before 70 was asking. We pay the tax and what happens therefore? And obviously, you can't expect him to tell you, go to the High Court and get it converted into 73, we will still give you the benefit. You can't be expecting the government to say that. But that's an option available to you. So, whoever has got a 74 notice and you think it's really a 73 proceedings, tax is indeed payable, but you want a waiver of the interest and penalty, take appropriate decisions. Whom you will have to contact? Badri is there. Yes, sir.
Sir, I'm not sure I could articulate my question correctly at that point of time because I thought the answer which was given was for this, but my question was not this. My question was that if I have already paid taxes along with interest and penalty or an NOS ruling under GST, now that department is telling that you can actually have a zero rated if there is input tax credit available, can I get, why should not I get the refund of interest and penalty? Because the input tax credit is obviously revenue neutral, and circular 201 also says that the time of supply for an input tax credit on RCM is the date of invoice. So, considering that I can get invoice, input tax credit of 17, 18 also.
You should have waited for making payment till the issue of the circular. That's where the difficulty is.
Okay.
That's where the difficulty
Now,
is.
can I approach the court for this?
No, sir. I'll tell you, any amnesty scheme, it's a package. You take it or leave it. No amnesty scheme is a combination of a hybrid situation. No courts will allow it. Either you take the amnesty scheme or you don't take the amnesty scheme. Fight on its own. You fight that it is a case of 73. Forget this amnesty scheme. You be confident that you will succeed on 73. You succeed on 73, you get back your interest and penalties at least. Interest not sure, but penalties at least. So there, that's what I am saying. It's a combination of either you take the scheme or you don't take the scheme. You cannot say that I have paid the tax and interest and penalty. You say that I am not supposed to pay interest and penalty, right? So why should I be discriminated against somebody who has not done anything? He was wise enough to wait for the circular, right? That's only. I mean, all these things happen. You can't. You would have paid the tax in order to arrest the interest, right? But then again, the zero rate, input tax credit, it has its own combinations, right? So this is what, therefore, what will turn around on this, what you can do is something which we have indicated. How do you go about it? It's for you to decide. Yes, sir.
I have questions on this amnesty scheme. I have paid the tax, interest and penalty I did not agree.
You did not pay.
I paid the tax, I did not agree for the interest and penalty because I am of the view that it is related to raising of the debit note. So I said that when the debit note is raised, at that point of itself is the time of supply, so interest applicable is what is the argument. Now the demand has been issued for interest and penalty, tax has been appropriated. Whether I can claim the benefit under this scheme, sir?
No, you have paid the tax.
Yes, sir.
Now, is there a notice issued under 73 or 74?
74 it is issued, sir.
74. Therefore, this prohibition of the scheme not being available to a 74 will still be there. you have to get that as a proceedings under 73. Only then this benefit will come.
Sir. Assuming that I get it under 73.
Then it is okay. Then you get the benefit of this. Interest
But
tax
it
is already
says,
paid.
Tax payable, so already paid, whether it will it be
That,
considered?
see, all this says is the amount, full amount of tax. This payable means the payable in terms of law. This payable is not the same as when you pay it.
Okay.
This payable means what you are supposed to pay in terms of the proceedings.
Okay, sir.
Liable to pay. So that you can do, but get it converted into a 73 proceedings, then avail the benefit of this before the due date.
Okay.
That's how you should do.
Sir, another question on this same subject.
Sorry, can we keep the questions for the question and answer hour, please? We'll let him complete the slides.
Okay, sir.
His worry is that your dinner also will get delayed. That's his worry. So, now this is 128A, a continuation of it. So, where it is 74, therefore, all the consequences would be followed. Yes, 147, where the input service distributor, this is actually a welcome move that has been made by the government. This was in terms of initially all of us would be aware whether this input service distributor is really compulsory or not compulsory. Can it be a substitute for a cross charge? These disputes were always there, and ISD was always an option available to companies. It was never made mandatory. But then the department started taking a view that you have to necessarily do a distribution of tax, distribution of credit. You cannot choose the option of cross charging the between entities, and therefore you have to necessarily go through ISD. Then they discussed, came out with a provision saying that yes, ISD is, we will make it mandatory from a particular day, and this is for all the credits that can be distributed prior to this date. This is an provision giving you benefit for the past period. All of you can avail of it wherever the distribution has not been done so far. This is on the anti-profiteering method. They have said they will put a stop to this because anti-profiteering investigations have been going on since from 2017 almost till 2023-24. So by this time prices would have got settled, contracts would have got concluded, etc. So there is no point in continuing this provision. Therefore, they said that you will not accept any request for examination. Instead of saying that it will come to an end on a particular day, they have put it in this manner, provided that the government by a notification specify the date from which the said authority shall not accept any request for examination of the price. And all anti-profiteering issues will now go to the principal bench of the GStat as and when they will notify it. Few activities which they have put under Schedule 3, all of us would know. Schedule 3 is where it is classified neither as goods nor as services. So, these co-insurance premiums where there is an apportionment between the lead insurer and the co-insurer, those activities all have been put under Schedule 3, so that it is neither a supply of goods nor a supply of service. This, as I said, the amendment we made and we saw in CGST has been incorporated into the IGST law. This on again on export duty. This is on the appeal to be filed, pre-deposit reduced to 40 crores from 50 crores. Right. We quickly run through the circulars. Maybe my view could be slightly different on some of the circulars, but I should start with the caveat. All the circulars have been drafted very well. The grievances have been understood very well. To a larger extent, it has been clarified the way the trade was anticipating. It has come out very well, but here and there are few aberrations that have been done, which we will have a look at it. Now, how do you utilize the circular? is for all of us to decide how we use it. Right? That's how you should see at the circulars. Monetary limits, these monetary limit circulars, earlier also we used to have it, now also they have done it, where monetary limit consideration, GST tribunal, High Court 1 crore, Supreme Court 2 crores, right, and all these with reference to appeals by the department. These monetary limits are for appeals by the department. There was one issue that, of course, that there is an exclusion for all this monetary limits. Suppose you have challenged the virus of the provision, any rules, any circulars, and if suppose it relates to valuation of goods or classification which has got a recurring impact, or any strictures, adverse comments have been passed against the government, or it is necessary to contest the interest of revenue. These exclusions were always there even earlier. The monetary limit circulars always had these standard exclusions, right. If they want to decide, they can always put that particular matter under any one of the exclusions and decide to file an appeal. But if they don't want to file, they can choose to saying that there is no recurring impact, right. Sometime before there was some position of department not filing appeals in the Supreme Court, but some of these days we find that in most of the matters they are filing appeals. It has come back to the same trend of filing appeals in number of matters. There was one issue that had come up, one of the questions that came up when we were framing it. Now, in these appeals that are filed by the department, can the department say that we will not file an appeal? Yes, because of this monetary limit. But even though the issues are small, less than 2 crores, less than 1 crore, etc., we can still initiate revisionary proceedings, because that can still be done. Revisionary proceedings, etc., can still be done. Can they do it? On a strict interpretation of the provisions, the answer is yes. Even if they decide not to file an appeal, they can still initiate revisionary proceedings in respect of those cases. But optically, they will not do it. Once they decide not to file an appeal in a particular manner, in a particular matter, because it is less than 2 crores, it would not be logical if they decide to do a revisionary proceedings in respect of that particular matter. If the issue is different and issue is going to have a greater impact, they may. But normally, they would not touch a matter where they decide not to pursue it further in terms of the appeal. Optically, that it will not lie correct. Then this is on special procedure for manufacturers of the specified commodities. This is more on some of this commodities where the Package Commodities Act, etc. is there. What is the compliance to be done? What type of packaging you should have? What is the declaration you should have? There was some ambiguity on whether what is the GST compliance, whether they should come out of it. So all these are only for that how you should put a particular make or model number or optional, year of purchase of machine is required. So all these are required for commodities where special procedure is prescribed. Right. This is one where place of supply to unregistered customers will be based on delivery address. This is circular 209, where the confusion regarding place of supply, where the goods are to be delivered by a supplier at a location other than the address on record. There is an address on record, but it has to be delivered to a place other than the address on record, which will be the place of supply, because essentially you go by the address you have it on record, either the address of the receiver or the address of the supplier. These are the only two things available in the definition. There is no third definition unless it is a bill to ship to case, where again you can have a person actually receiving it. He will also be considered because his address also will be there. Now what happens if you are delivering it to an unregistered person, where he is located in a place other than the address mentioned in the document? They have clarified to say, in supply of goods to unregistered persons, where the billing address is different from the shipping address, the place of supply shall be the address of delivery of goods recorded on the invoice. So, even if it is address of the receiver is different, you can have a delivery address which is different from either of the two addresses, you will go to the place where the delivery address is mentioned. If full input tax credit is available, then in terms of rule 28, your value is to be accepted, right. Now, two further clarifications they have given in the context of this, either in this circular or other circulars also, that one, suppose you don't raise an invoice at all. Suppose in the case of an import of services, let us assume the foreign supplier doesn't raise an invoice at all. What happens? Right? They said, no, even if he doesn't raise an invoice, consider that to be a value which is equal to 0. That value 0 will be considered as an open market value in terms of 28 and accept that value. In other words, even when invoice is not raised, the value is 0. Don't attribute a value to it, because whatever value is there and on which input tax is paid, it will be available as input tax credit. That is the final portion, right. They have also said that even if the value is considered as 0, accept it. So, one is value considered at 0, accept the value. No invoice is raised, accept the transaction, because in both the cases, the consequences, he will take the entire input tax credit, right. How do you marry both these situations? In a case where there is an import of service, value is not declared, right, and you want to take the benefit of both these circulars. You should also remember, this circular also says that if you want full input tax credit, you will get the credit, but there can be an interest component towards it. There will be an interest component towards it, right. You may get the credit today, but you will have to pay the interest, which is the delayed payment of interest, because you have not paid the tax in time. So, one, if you have not paid the tax in time, you will have to pay the interest. The circular also says if it is 0 value, value is to be accepted. 3, if no invoice is raised, then also it is to be accepted. If 0 value is to be accepted and no invoice is to be accepted, can there be a situation where you can have a situation of interest being there for a delayed payment of a tax? There is some disconnect between that and availability of credit. So, the best way would be, 1, make a claim that you are entitled for the full input tax credit. Say that since 0 value also is to be accepted, therefore, no interest is payable. Therefore, in all cases of NOS application, Northern Operating Systems application, state a case that even if I have not paid the tax, since I can get full credit, there should not be a demand. If there is a demand, I will get the full input tax credit, but I do not need to pay the interest. These are all questions, issues you will have to raise in all second one matters, right. So, now this one is only on this import of services from a related person. It would deem to be a supply without consideration in terms of entry. 4, importer is liable to pay tax under RCM by determining the value of supply by applying rule 28. Now, what is this clarification they have done under 210? In the light of their earlier circular of 17/7/2023, which is what Bala was referring to, clarification regarding taxability of services between distinct persons was provided. The second proviso to rule 28(1) is applicable in all cases involving supplies between distinct as well as related persons, where full ITEC is available. Hence, the value declared in the invoice will be the open market value. If the invoice is not raised, is not issued by the related domestic entity, the open market value of such services may be declared to be nil, deemed to be nil. And this clarification is what they have used it for import of services also. Right? The ultimate funda is, if you get full credit, accept all your values, which is also in line with the normal taxing principle. As I said, they do not want to go after a transaction where credit is available. (211) again same thing, you will go by the time of supply for issuing a self invoice, and the relevant date for availment of credit is the date of invoice and not the date of the actual receipt of service. This is because this circular gets issued, there were few advanced rulings that took a different view, that your service was rendered earlier, we have issued an invoice now, therefore your time limit for taking credit is gone. They said no, you go by the date of invoice, so you can get the credit even today. Evidence of reversal of ITC for post supply discounts, post sale discounts. How will you, suppose a discount is given after the supply, somebody would have taken the credit of the initial tax paid, then how will you reverse the credit? There was no mechanism that was provided. They have now said in the circular that you can get some certificates by the chartered accountant saying that this discounts have been, the credit has been reversed, so that the discounts fall in place. ESOP, I think, has been discussed enough by a person from Delhi, so there is nothing for me to get into all this. This is a view which we had entertained maybe about 5-6 years before, that this is absolutely stupid to tax an ESOP transaction to say it will be a supply. When you consider the activities by an employee to an organization as a Schedule 3 transaction, saying that is not considered as a service, and therefore a salary paid to him also will not be a consideration for any service. To say that an allotment of shares to him as part of his compensation, that activity will be identified, isolated and taxed, that I do not think it would ever stand the test of law also. This is that investment portion on life insurance premium. They have clarified it well. It is a good clarification if you look at this. In terms of 247, the portion of premium which is not included in the taxable value is neither nil rated nor wholly exempted, and also a non-taxable supply. Hence, non-inclusion of certain portion premium in value of taxable supply per se will not make such portion attributable to non-taxable or exempt supply. No requirement of reversal of ITC under section 17. They are looking at the entire activity as one activity, not dissecting it as taxable and exempt activity. This circular can be used in respect of so many other situations if it comes to. This is insurance company to pay GST on salvage rec value. Different situations, these are all specific situations that has been examined and clarified. This warranty, extended warranty, where the manufacturer gives warranty out of his stock, then the credit need not be reversed. If it goes to a distributor and then he extends the warranty, also it need not be reversed. If it is done, if the manufacturer does it out of his own stock because of the warranty period, also it need not be reversed. In other words, the logic is this: when it is a warranty, it is part of a sale price, and on that sale price initially tax has already been paid. So whatever you do subsequently is part of that value only. Therefore, you are entitled for the full credit. ITC for motor vehicle repair expenses, they said different situations have indicated. Whether insurance companies for repair expenses reimbursed by the company, what happens, who will be entitled for the ITC. where the insurance company pays only for the approved claim amount. Any amount over and above is to be paid, what extent he will be entitled. So, specific situations have been clarified. Loans provided by overseas entity to Indian entity or by a person to a related person is taxable when no consideration is charged. They have clarified it to say, in the absence of a consideration being charged between related persons or by an overseas affiliate for extending loan or credit other than by way of interest or discount, the same does not amount to a supply of service, where you are only simply collecting the interest and passing it off. This, of course, Badri asked whether this can be done. I do agree that the logic in this circular can always be extended to any situation where it satisfies the definition of plant and machinery in section 17 itself. Because not everything connected to immobile property is excluded under section 17. There are certain exceptions to that also, where it is used as a plant and machinery, etc. You can bring it as part of the plant and machinery, you will always get the benefit. Their intention is clear, of course, they do not want to expressly extend it to other situations. This is place of supply for custodial services provided by banks to foreign portfolio investors. They have clarified it based on the old education guide that these custodial services cannot be covered under services provided by a bank to an account holder in terms of explanation to section 13(8) of the IGST Act. So, it will be the location of the recipient, so it will be an export of service. And even though it refers to the education guide, you can safely assume that whatever applies in the education guide in 2012 can always extend to the GST also. We have used it in the courts in a number of cases. So, therefore, we can safely say that whatever happens in the education guide, and there are a lot of, for example, I can give the example of intermediary. Education guide gives a particular definition, explanation, and that is what is captured even by the government in the circular of 2021 in the context of GST. So, they have issued it in a number of places. So, you can use the education guide safely for any number of years, still the education guide is withdrawn. This is National Highway Projects in Hybrid Authority, where there was a lot of confusion because of some of the decisions, etc. So, they have clarified that if the installment includes interest, it will be part of a taxable value, all that they have clarified it. Spectrum usage charges by telecom operators, they have indicated it will be a continuous supply of service, because it will be the usage will be on a continuous level. So, depending upon when the taxable event will happen, they have indicated we will tax it. You asked for it, he gave it, that is all. Nobody should have asked for all this. It is 10% is payable, 10% is paid. You can't pay 20%, go to the High Court, get a stay. You don't want to go there, then pay the 20%, give a declaration. That is what they have clarified. Corporate guarantees between related parties. Now, always remember the same logic of full input tax credit being available is also there in throughout these corporate guarantee circulars. In fact, the rule itself is made only for transactions of corporate guarantees between related parties, that 28 subclause 2 or something proviso, that though it has come from 2023, right, but still it will applies only between related parties, because for between unrelated parties, one, there will never be a corporate guarantees that are being given, very rarely that will be given. If it is given and if there is no consideration for giving the corporate guarantee, there will never be a tax. But for transactions between related parties, if the corporate guarantee is given, there will always be a larger question whether giving of the corporate guarantee by itself is a supply. Because you give a corporate guarantee, what are you trying to assure? You are trying to tell him that if this person defaults, I will pay. the guarantee is not given on the hope that he will default, right? It is given to assure somebody that he will not default. If he defaults, I will pay. So whether that will amount to a supply is something which needs to be tested. But assuming it amounts to a supply, then it will only be a situation where what will be the value. They have come out with a 1% or the actual consideration between the related parties, whichever is higher, and where you now apply all the earlier circulars with reference to related parties. So value, you don't charge a consideration, no tax. Full input tax credit, whatever be your value, that will be the value accepted. If you want to give 1%, pay on 1%. If it is going to be 0.25% you pay that. But all your related party transactions will be where full input tax credit is available. And if the parties to whom you give the corporate guarantees are outside India, then it will amount to an export transaction. This circular also clarifies that. So then there will never be a taxability of those export transactions. So corporate guarantees, assuming that they are taxable between related parties, you have methods to attribute a value to it and pay the tax, so that other person takes credit. You want to go on a larger question of whether it amounts to a supply, etc., that depends on a factual situation, how much you can do it. But always remember, it has to be a value on the amount which you guarantee. That's very important, because we have come across situations where they have taken 1% of the loan amount. That loan, you will be guaranteeing maybe about 20% of the loan amount. The loan amount will be 100 crores or something. So they would have taken 1% of the loan amount. That can never be the basis. It is only 1% of the guarantee amount. Upward revision in price, these are all existing refund claims they want to clarify, saying you will get the tax credit. Canteen stores department, the special purpose vehicles and all, we had specific issues of railways, special purpose vehicles providing it to the railways, etc. That they have sought to clarify. What was not taxable even earlier, they wanted to tax it based on some GST Council recommendations. They have clarified this. Yes, sir. I don't think anything else is there. Yes, please.
Sir, PVS sir, may I request you to please come on to the dais. I was just telling Mr. Shivadass, saying all of us have a lot of questions to ask. So let me kind of, yes, Mr. PVS, I think I should say this. We are extremely lucky to have these two gentlemen sitting in front of us and giving answers to our queries and questions. Normally what happens, you take any of the names that are put here, maybe Sansera or West Coast or Bueller or CNC or Fundamax, anything, Generally, I'll say that I am from Fundamax, I am from HUL, I am from Wipro. But the two gentlemen sitting here, they have to say, I am PVS and I am Shivadass, because they are by themselves, right? So we are extremely lucky to have both of you here, sir. Thank you so much. So let's use this opportunity, rather let's exploit this opportunity of the two gentlemen sitting in front of us. Sir, so many circulars, so many changes. As you said, the circulars are drafted extremely well, no doubt. I think Bala also confirmed, saying one on the ESOP side, you should look at it conceptually, because the non-taxability of it comes through another circular by itself. So there is a lot of thinking that has gone. Let me take one question for Mr. PVS to start with. Sir, on the stock options, it's a very highly debated topic. It's clarified extremely well, there is no doubt in that. But towards the last part of the circular, if we see, they say that, if there is a markup that is charged by the overseas entity to the Indian subsidiary, then that amount will be taxable. But in the same breath in the circular, they use the language there are some words that are used. One is called the markup. The other is, they say, because the entity in India is only doing a job of arranging and facilitating. This actually complicates our lives. When we say markup, shouldn't it take the color of the very principal element that is being transferred? The principal supply, if I may use the GST language. Shouldn't we equate markup to a trading margin? Suppose I'm selling exempted goods. It is not that on the markup I have to pay 18%. If I'm selling some petroleum product which is not liable, it is not that on the markup I have to pay 18%. Then why not apply that analogy to stock options also? Because circular itself calls it markup. So,
normally, if there's a supply of goods or services or both, then markup also will get embedded into the supply transaction. But in an ESOP transaction, there is no supply. If there is no supply at all, the markup is the only transaction you will have. Why ESOP is not a supply? Is because ESOP is what's called a mechanism of remuneration, where stocks are issued under certain conditions. There's a cycle for ESOP. You satisfy those conditions. Who is rendering service to whom? The employee is rendering service to the employer. That's the only service which is already clarified as a non-taxable service, and therefore it falls outside the GST regime. If that were to be so, the only thing which survives, if at all, is other things are monetary transactions. What the overseas company pays to the Indian company, or in a reverse situation, the Indian company pays to the overseas company, which is what is clarified in the circular. That will be more like a monetary settlement between the two companies. There is no supply of service there. So accordingly, there won't be any markup. What are the three elements is, who is rendering service to whom? The employee is rendering service to the company, which is the employer, and which is in the circular is the Indian employer. You can even flip it, and it will be the foreign employer who is receiving the service for the employees who are overseas. Number two, what is being issued is security. For whose services the security is issued? It is not the company, intercompany services the security issued. Then it will be a compensation. Then the markup also can get embedded. It is a security issued to the employee for having rendered the services. So I would say keeping these components into the circular takes into account all these aspects. It has clarified. And since there is no other element of service which is embedded, the markup alone remains as the only service for which there will be a GST. So the principles are consistent. Even the example you took, if the basic supply is a supply of goods or services, or both, as the law is very consistently, then the markup also will get the characterization which is there in the basic supply. Otherwise, the markup will be separate.
Sure. Thank you, sir. Sir, maybe an added question to Mr. Shivadass on this. Sir, in the same breath, in the same paragraph, they use the words, the phraseology that is there is, the Indian company does nothing but arranging or facilitating services. That is exactly the language that is used for intermediary services. Now, intermediary services, the place of supply is the location of the intermediary. So, in this case, if we apply in a strict way, then the place of supply becomes overseas. The place of supply, because the foreign company is located outside India, can we take this argument, sir, when we are before the court? In which case, the place of supply becomes outside India, not taxable. Even the markup will not be taxable on that ground.
Should be possible. I don't think there is a problem there.
Okay.
Especially when you consider, now the problem is the analogy of the place of supply for an intermediary can be used. Because the foreign company in that sense is not in the same as an intermediary under the Act. Because the definition of intermediary under the Act has got specific situations. And who has to be an intermediary, what it will be, etc. So I don't think you can call the foreign company as an intermediary. Yes, but as an analogy of what happens if it is an intermediary, you call his place to be the place of supply. That we can use to say that foreign company's place is outside. He is the one who is arranging. Therefore, if the place of supply is outside India, it will not be within your taxing jurisdiction to tax it.
True.
Whether it amounts to import, export, that's a different point, but you cannot tax it, and therefore you cannot
Sure, sir.
tax even the markup.
Sure. Thank you, sir. Thank you. Sir, next one is for you. On the input service distributors, you know, the amendment which has come now, it looks a little too logical that, you know, did we really need an amendment? It was always meant to be that way. If you can just help us understand how it will impact the industry.
At first cut, it sets the first principles very well. Normally, if you can identify the recipient, put it to the recipient. If you can know the collective recipients but you don't know exactly a portion amongst them. But if something is very common across the organization, then you have to allocate it based on the turnover, irrespective of whether they are. For example, we had one illustration, somebody raised it, that suppose I have got an exempt division, and that exempt division is having a turnover. Normally, it wouldn't have got allocated. Now I have to allocate it. Suppose I have a foreign branch, which is now kept out for a moment, that I have not put the tax to it. I may have to allocate it even to the foreign branch if there's a common service. So I think we have to slightly broaden it to imagine that what all we kept it out in the earlier understanding, those things may get included if it's a commonality about it. So if you have specific beneficiary registrations, please allocate it them. If you don't have specific, but a cluster of specificity, but you don't know exactly, allocate it only amongst them. If it is universally common, then you have to do it, but including those which are exempt. So that will be the principle. I think that clarity, the last one, that I have to include something which was otherwise I did not earlier do, the commonality, that one will be the one which will, for example, foreign branch, or I think that will be the one which will be. So last one is a variation to our understanding. If people have not followed the last one, which I think my own gut feel is many wouldn't have followed, possibly we have to correct it.
No, also, if you look at the type of litigations that were involved on this ISD, till they said that we will make it mandatory from a particular date. The department always was saying that they were cross-charging, they were rather mixing up the aspect of cross-charging with the input service distributor. They were always mixing it up. Now, therefore, to put an end to that sort of a controversy, it was decided that ISD will be made mandatory from a particular date. And if that was the purpose, therefore these rules had its own place. But otherwise, there was always a problem of cross-charging being substituted for ISD, where ISD, what does ISD essentially mean? It is for all the credits which you get, you want to distribute. Cross-charging is what your output activities you have to cross-charge. So they were always mixing it up. Therefore, this amendment was required to clarify that position.
True, sir. True.
But the challenge now is how do you identify specificity? That is going to be a difficult task for many people, because what may appear to be specific may not be as specific as you think. For example, most software companies may have a license contracted, say, for 1 lakh licenses. The actual use of licenses may happen over a period of time. Now, that time which is going to happen may be a little later, but the ISD has to be distributed immediately. So those are the challenges which will continue to remain, if I have to say.
And very importantly, sir, if I may add to what you said, when it is a case of a cross-charge, he becomes an outward supply service provider, whereas in case of a distributor, he doesn't become a supplier. Sir, on the credit notes, we have that credit notes which have come for kind of reduction of the output tax, subject to the condition that the recipient has reversed the input tax. Sir, you have been a part of very many discussions on this aspect. Something for us to kind of take away.
Credit note, the CS certification.
Yes, sir.
CS
yes,
certification.
Yes, sir.
I would have personally allowed if they had said it on self-declaration rather than a CA certification, because the onus of getting a CA certificate, the two from a other entity that they have also not availed the credit, is not going to be a very easy one, because it puts a very huge obligation on that industry. It involves some amount of cost also for them. It's not easy to verify old records. You may even find that the records are not made available to a CA. I don't think he's going to certify it. I would have rested the case, because there is something called GST is based on contemporaneous documentation. Whatever you generate during the trade transaction, those are the documentation which should support the transaction in entirety. This is an afterthought. If it is an afterthought, you don't validate an afterthought by saying, yes, give me a CA certificate. A CA certificate is my defense. It's not the government's defense. If I need to produce, I will produce a CA certificate to please look at it. Please don't examine further. This is certified by a competent expert. Please take it on record and close it. It cannot be the government's evidence that you please it.
Yes, sir. Sir, one question to you, sir. You spoke about the input tax credit, the 73, 74 going away and 74A coming, and the embargo that is there in 17.5I, which says if it is 74 or 129, 130, then I'm not entitled to credit. Now 74 is also gone. Sir, what happens to the past cases? Because 74 is gone, let me put it this way. If there is an assessment that is getting concluded on a current date, after the bill gets the presidential assent, while 74 still continues to apply for the earlier years, assessment may happen in 2025 for one of the earlier years. That day, sir, how will the court look at it? Will we be able to kind of claim the credit because 74 is gone away from 17.5?
No. See, the court will look at the provisions as it stands on the day of your liability to pay tax. So the date of assessment is more with reference to a procedure which they have to adopt, and you keep extending the annual date, annual return dates, etc. So I don't think that would really be relevant to look at whether the credit availability has to be looked at from what is there today on the date of assessment. They will always look at from the way the provision was there at the time of payment of tax.
Okay.
So you will go by a 74 earlier.
Sure.
Now it's a different thing to say that look at the intention of the government. The intention of the government is very clear, not only from removal of bringing into Act 74A or the removing 73 or 74 out of this embargo. Look at the circulars being issued. Look at the consistent view of the courts. So looking at that, the flow that is there is if somebody gets credit, you cannot be accused of suppression, etc. Why not take that view in a particular set of facts?
Okay.
You cannot apply it as a general rule. You can apply it as a set of facts going by the general trend of even the understanding of the department.
All right. So on a lighter way, if we have credits, if we have taxes that get paid and it is under section 74, we know where to go to subsequently. Now, we'll take some questions from the audience.
You said it. I did not say it.
Yes, sir. I said it. Anup, yeah.
Hi. My question is on circular number 212, where credit note to be issued from the recipient point of view. How does we compute that? How does we compute that 5 lakh rupees, above 5 lakh? Is it invoice value, tax value, one credit note, multiple of credit note? How do we compute that?
Any idea? Up to 5 lakhs, you don't need a CS certificate. Beyond that, you need a CS certificate.
What would be the credit note? Credit note will be for the amount of discounts that are being given, correct? Now, that can be given by one credit note. See, the problem is, these credit notes will be in terms of the credit notes that are required to be done in terms of the system, correct? Now, if you have a GSTN credit note, that automatically reduces the value if you comply with the provisions at that point of time. These are all credit notes you are talking today about discounts that get passed beyond the GSTN system, correct? So it's not GSTN credit note, it is a commercial credit notes. Now commercial credit notes, you have multiple credit notes or 1 credit note, that doesn't make a difference. 5 lakhs will be with reference to the amount of discounts. If the amount of discount is more than 5 lakhs, get a CA certificate. How will the CA give you a certificate? He will have to look at your invoices, how many invoices you have raised, what is the discount, how did you compute the discount, did you have 1 credit note, do you have number of credit notes? It's for him to decide. But that really doesn't make a difference. 5 lakhs is equal to 1 credit note, multiple credit notes, no. That 5 lakhs will be the amount of discount which you are claiming as a reduction from the ultimate value for the reversal to take place and then for you to take into account. That doesn't make much difference.
Thanks.
I would have loved if the circular had flipped it in line with your question, that CA certificate is required for 5 lakhs, not required above 5 lakhs. Possibly that question will be easier to handle because up to 5 lakhs is easy to get a CA certificate. Beyond that only it becomes a problem effectively.
Unfortunately, they've not barred any amount that chartered accountant should not be charging so much for that, such certificates.
I'll just add to what Sir mentioned. I think you should look at the 5 lakh threshold in line with the earlier circulars which have come in respect of similar adjustments that are required.
It is not the administrative
on a
cost.
per annum basis.
I'm not looking at the fee. Fee may be whatever it is fine. The inability, see, normally I have a process to generate what is the link. I can get an endorsement. So there are many other commercial ways of endorsing that they have reversed it. If those proof of concept is there, why need a CS certificate? I think I'm on a more, it is a commercial transaction. One party has reversed it, the other party also should recognize it.
I have one more question. I'll take it up one more. So the one more circular which says input tax credit, the last date to avail for the financial year, previous financial year is 30th November. How do we interpret that? 30th November return is filed in subsequent month of 20th December. Correct? So is it I have to take the credit?
No. Come again?
The input tax credit availment for the previous financial year, the last day is 30th November. Correct? 30th November, return is filed in 20th December.
Correct.
The 20 days due date, right? Now question is, how do I compute at 30th November while I declare that in 20th December, some of the officers says that you have taken that credit pertaining to November in December, they are saying that it's ineligible.
No,
Point 1.
The credit has to be taken by November 21st. 30th. You have to take it by 30th of November 2021. Correct? Your reflection in your return is not the date of taking credit. So therefore, if they say that since you have filed your 3B in December 2021, therefore it means you have taken credit in December 2021 is wrong. Right? The filing of a return is by a due date. But taking of credit in your books of accounts, which you can otherwise demonstrate, has to be before 30th of November. That should be through your documentation, etc.
Thank you so much.
Yeah.
It says in the circular the amount of tax, not the discount value, just for
Whatever it is.
Yeah.
Amount of
It's
tax
the
or everything.
tax.
That's okay. Then it becomes all the more difficult, as PVS says. If it is amount of discount, you can always go through your commercial documents. It's going to be tax. Then you'll have to demonstrate each invoice, how many invoices are there. If it is one invoice, no difficulty. Multiple 100 invoices, how do you compute 5 lakhs of tax? That's going to be more difficult.
Sir, the 53rd Council meeting spoke about something called a GSTR 1A, but neither the budget nor the circulars had any reference to it. So any idea about it?
1A is already notified. It is part of the amendment to the rules. 12 of 24.
Okay, sorry, I missed it. Yeah. Okay, now one last question on 210, circular 210.
The budget, etc., will not talk about this 1A, 1B, 3A, etc. That's a much larger scale.
Okay.
These are all procedures.
Okay. Sir, on the 210, circular 210, the RCM, I think that, the reference what they are taking about the input tax credit on RCM to be taken is with reference to Schedule 1. What I mean is, if the the subsidiary is not charging anything, then only the value is 0, right?
Serial number 4 and 6.
Okay.
It's 4 and 6 it refers. In the import of transaction it will be 6. Import.
Correct.
Yeah.
Okay, sir. Thank you.
Sir, one question
Entire
to you.
discussion
I'll-
of input tax credit being available and therefore don't go after the value is essentially in terms of transactions between related parties. Please be clear on that. And between related parties, most of the transactions will come under your Schedule 1. Right? You have a consideration, you may go under the general Section 9 or Section 7, but otherwise, essentially, they will come under Schedule 1. That is why they say that since credit is available, don't go after the value.
One challenge all of us will have, I think we will need to imagine, if there is no invoice raised, then also value is zero, then how do you know rendition of service has happened? Normally, the reverse condition that if there is an invoice, there is a presumption of rendition of service. This is a reverse case that if there is no invoice, the value is zero. How do you know that a transaction has happened between the two related parties? That challenge, we need to have some kind of a mechanism to say, yes, these are the conditions and the value is zero. Otherwise, you will have to get benefit from the circular. The circular says it's a service. The value is zero. Now, where is the service? Where is the identification of that service? That needs a little amount of dovetailing. It will go finer into your, how you do your transactions with your related parties.
Sir, in the same breath, I have an addition to that, sir, to you, sir, PVS, sir. You know, let's say there is no invoice that is raised, but there is a rendition of service either way. If there is a mention of this, or if this is getting listed as a related party transaction in my Form 3CEB from a transfer pricing perspective, how does that have consequence from a GST?
See, there's going to be some issue at the same point in time, because 3CEB refers to some transaction. Automatically, there is a value to be imputed for those transactions. If you imputed a value, you cannot call it zero for the GST and say it's only a value imputed for transfer pricing. That's going to be a problem at this point. Assuming that you, even for 3CB, you don't report it for a moment. And there's a later discovery, and at that point, as a secondary transaction, you have to bring the money back at a later point in time. Again, there will be a problem when you get visited. So these two laws don't speak to each other exactly. You can only hope that the GST assessment, TP assessment will happen after 5 years, the finality, therefore, you get the benefit of limitation.
No, I have a feeling that this portion of the circulars that talk about you don't raise an invoice, the value will be considered as zero, that value will be accepted, is prone to some sort of a misuse at some point of time. And therefore, those portion of the circulars can get withdrawn at some point of time. That's what my hunch feeling is.
My own feel is, wherever you know there's a clarity, there's a service, please put at least a cost as a basis and close it, so that you go through a transfer pricing assignment independently, because TP adjustments is a different price determination. It's not a consideration, but it's a price adjustment. So that can be technical arguments on that. But nevertheless, to rely wholly on this service and say I'm zero, I think can lead to some pride. For example, trademark, you can say we are all brothers and sisters, related parties. There is no charge because we need a commonality of identity. Therefore, there's no trademark charge. There's something called permissive use, and there are different concepts of trademarks. If you read the trademark law, you'll get it. You'll say this is nothing, no service involved, because commonality, we need this identity, that kind of an argument. For example, even corporate guarantees, you can say whether it's a shareholder service. If it's a shareholder service, please disallow some input credit to establish it so that there's a consistency with your stand. All these consistencies, if you bring, I think the stand can be a little better.
Sir, you mentioned about receipt of money, especially, the related party, we are talking about the overseas transactions. In that breath, there is a change there is an amendment which has happened to 96A. It has basically made the time limit, which was 1 year plus any additional time if the commissioner has granted any extension. Now they've made it coterminous with the FEMA guidelines to say as long as the authorized dealer is extended, you get it within that timeline. Sir, how do you think this will have an implication? Will it apply to outstanding which I have today, or where I have not breached the timelines? How would you look at that, sir? As in retrospective or prospective?
See, there are certain regulations which we have to, this is how I have been reading the law, I've been successful so far, I don't know, I'll succeed on this also. Normally you look at the mother law and derive the consequences. Yeah, realization of international proceeds is a FEMA regulated one, and that will guide as to when you should realize, and any other law prescribing a lower period or prescribing a more onerous requirement, I think that should be dispensed with, and the FEMA law will prevail in those kind of transactions.
All right.
Here also, if the RBI is the competent authority to prescribe when I should realize and is the competent authority to extend those deadlines, to say that the commissioner will determine whether I am capable of realizing it earlier, it is a subordinate legislation and therefore it should be ignored. Just as I would argue that SEZ Act prevails over all other acts, even GST Act for that matter, and therefore the mother law should be looked at wherever it's more important than the subordinate law. I think that will be the kind of principle I'll drive home. Needs to be tested, so that it's prospective or retrospective, but I would think these are all regulations which always prevailed. The commissioner should not have been the authority at all, because there's a wrong prescription of an authority who doesn't have the ability to judge when it should be realized. It should have been always RBI. That commissioner was wrongly notified cannot be a penalizing mechanism on the trade and industry.
Yeah. Some questions from the...
So my question is with respect to credit note. So even numbers are different, but the point here is rational. When there is no law which says certificate, why you have brought a circular to say that you take a certificate? You are burdening the taxpayer. Similar circular has been issued for purchase register reconciliation. When 36(4) was introduced in 2019, and you are bringing circulars for 17, 18, 18, 19, why there was a requirement per se, when the law was not there? You are unnecessarily burdening the taxpayers to say that my duty I have not discharged, but you discharge on my behalf.
No, I wouldn't jump so much. I think there are certain aspects which we like, certain aspects we don't like in a CA. I don't like the CA because it's not contemporaneous, it can be one way. If I can give you counterparties' affirmations, that should be fine, is my way of looking at it. But assuming that you have to solve it from a regulator, he doesn't believe anything, and he says that I want to not allow this, whatever you are, therefore this liability remains for you, because I don't know whether the other guy has also reversed it. To avoid a litigation, sometimes you take this kind of circulars to say, okay, you produce a CA certificate and close it. One way of looking at it. I would only say that CA certificate could have been given as an alternative if proof cannot be submitted as a satisfaction. Okay. I think it's, CA certificate be a closure of a dispute rather than a trigger of a dispute. Yes.
Well said, sir. Sir, I have one question for you, sir. We have these appeal-related provisions where pre-deposit amounts have changed. Now, how would this provision apply? In the sense, two questions in this. One is, if will it apply for all the appeals that I'm going to file after the finance bill gets enacted, wherein I pay a 10% additional duty if I pre-deposit if I have to go to the tribunal, or how would it apply, sir?
No, this will apply to all appeals filed on or after the finance bill is enacted.
Okay. A mischievous question, sir. Pardon me. I've already paid 20%, say. Is there a way to get the 10% back, sir?
Succeed in the appeal.
Sorry, sir?
Succeed in the appeal.
You will get the full. You will get the full money back.
All right. Something more. Yeah, somebody there.
Sir, my question is related to the amnesty scheme. So in the show cause notice, if there are multiple issues, and if I want to close only one issue under the amnesty scheme, is it possible? And for
you go by the complete show cause.
Complete show cause.
Partial amnesty is not there.
Thank you, sir.
No amnesty scheme works partially. You go to the entire show cause or you don't go through it.
Sir, I think we'll close with that. That was the last question. Sir, thank you so much once again for your time. Somebody there? Okay, one last question. My colleague, sir, I will not say no to him.
Last question is, when is the dinner, is what he's going to ask.
Sir, the question is on the amendment of 16(5) CGST Act, which says credit of 17, 18, 18, 19 and 1920 can be taken up to 30/11/2021. So when I filed my GSTR 9 or 9C, I realized that 17-18 credits were taken beyond the timeline, and the corresponding client was asked to reverse those credits. And they also reversed those credits through DRC 03. The fact that the reavailment does not have a timeline, can I reavail those credits back now?
No, I didn't get your question. That you are reversed, you are availed and reversed.
I have availed the credit, but I realized it is beyond timeline, which was originally beyond the specified timeline, say 30th September 2018 or March 2019. So therefore, I asked the client to reverse. The client reversed that credit through DRC 03. But the fact that the provision stands today.
So once you are availed, subsequent reversal, reavailment is not a bar in my view.
Exactly.
I will request senior advocate to clarify.
No, what answer you want?
I would want to reavail, sir. I would want to reavail, sir.
No, you want to take, you don't want to take.
I want to take.
You want to take? No.
Yes, sir.
Take it. What is your problem? Government says you take it, you take it. If suppose they say you have already taken it and reversed, then that time we will see. What are you worried about it? Government says take it, take it. That's
Sir,
all.
coincidentally, that is the answer I've given him. Avail, and we'll go to Mr. Shivadass for help.
First, the initial availment is completed.
Yes,
You have
sir.
met the statutory standard.
Yes, sir.
Any number of reversals and retaking are all only your mistakes. Not legal mistakes, I'm saying.
Thank you, sir.
Thank you. It's been a wonderful discussion. Thank you so much, sir. Thank you. Just one second. May I request Mr. T.G. Ramakrishnan to give them a memento, please. Sir, please.
Sir could have been here and given the lecture also.
Maybe some questions can go to TG.
Thank you. Thank you, sir. Thank you once again. A wonderful discussion. Thanks.